Cyber libel. Under Section 4, letter C, number 4 of RA 10175, cybercrime punishable includes content-related offenses such as cyber libel, which is an unlawful or prohibited act of libel as defined in Article 355 of RPC, committed through a computer system or any other similar means which may be devised in the future. The phrase acts constitute the offense of cybercrime punishable under this Act in Section 4, letter C, number 4 of RA 10175 means that libel defined under Revised Penal Code committed through computer system is punishable under RA 10175 and not under the Revised Penal Code. Unfortunately, Section 8 of RA 10175, the penal provision of the law, fails to provide a penalty for cyber libel under Section 4, letter C, number 4. Thus, the offender cannot be prosecuted for cyber libel under Section 4 in relation to Section 8 of RA 10175. For committing libel through the Internet, he should be prosecuted for libel under Revised Penal Code with qualifying circumstance of use of information and communications technologies under Section 6 of RA 10175. With this qualifying circumstance, the penalty for libel under Article 355 of the Code shall be increased 1 degree higher. Angelina maintains a website where visitors can give their comments on the posted pictures of the goods she sells in her exclusive boutique. Bettina posted a comment that the red Birkin bag shown in Angelina's website is fake and that Angelina is known to sell counterfeit items. Angelina wants to file a case against Bettina. The crime committed is cyber libel, or libel with a qualifying aggravating circumstance of using information or communication technology in committing a crime, 2010. Multiple publication rule. Other jurisdictions have adopted the single publication rule, under which any single integrated publication, such as one edition of a newspaper, book, or magazine, or one broadcast, is treated as a unit giving rise to only one cause of action, regardless of the number of times it is exposed to different people. It is settled, however, that a single defamatory statement, if published several times, gives rise to as many offenses as there are publications. Each and every publication of the same libel constitutes a distinct offense. This is the multiple publication rule, which is followed in our jurisdiction, Soriano versus Intermediate Appellate Court. In sum, republication of a defamatory statement constitutes libel, which is separate and distinct from the previous libel, arising from the first publication of the same defamatory statement. Since libel arising from first publication of defamatory statement is different from the libel arising from the republication thereof, libel is not a continuing crime. The concept of continuing crime is not compatible with the multiple publication rule. Under the continuing crime rule, there is only one libel arising from two publications of the same defamatory statements, since the republication thereof is just a continuation of the first publication. There is a theory that libel published through the Internet is a continuing crime as long as the defamatory statements are accessible to the public through the Internet. The publication of the libel in the Internet is continuing, and thus the commission of libel is also continuing. Under this theory, the one-year prescriptive period for libel shall not run as long as the libelous statements are still accessible to the public through the Internet. It is submitted, however, that this continuing publication theory will go against the essence of the rule on prescription, and that is to fix a reasonable period within which a criminal action can be instituted. This view will render the crime of libel imprescriptible, since it is of public knowledge that defamatory writings posted in the Internet will be accessible to the public even after several years have elapsed. Moreover, defamatory articles published in a newspaper such as Inquirer several years ago are still accessible to the public in the National Library or other libraries, and yet the Supreme Court in People v. Guinness did not consider the accessibility of the defamation in the newspaper as a factor in determining whether the prescriptive period will commence to run. In this case, it was held that the prescriptive period of 1 year for libel shall commence to run from the day the alleged libelous article was published.